Welcome to the Deep Dive. Today, we're focusing on something really important for California renters: hidden tenant rights in California repairs and safety.
That's right. Many tenants, maybe even you listening, aren't fully aware of just how protected you are when it comes to keeping your rental home safe and, well, livable.
Exactly. And we've gathered some key info to unpack these rights. It's worth mentioning, as an attorney from the Martinez Law Center in Santa Ana, our firm focuses specifically on helping tenants.
Yes, our specialization is tenant-side eviction defense, unlawful detainers, partitions, and also premises liability accidents in apartments. We work across Orange County, Riverside, San Diego, and LA. Only for tenants, never landlords. You can find more at martinezlawcenter.com.
Great. So our mission today is really to arm you, the California tenant, with the knowledge you need about repairs and safety standards. Let's start with the foundation, this concept of the implied warranty of habitability. Sounds legalistic. What's the core idea?
It sounds technical, but it's fundamental. Basically, California law says every rental agreement automatically includes this promise, this warranty from the landlord.
Promised about what?
That the place is fit to live in, safe, sanitary, habitable. And crucially, this applies throughout your entire tenancy, no matter what condition it was in when you moved in. This comes from a big case, Green v. Superior Court.
So it's not just about whether the paint looks nice or the carpet's new?
Not at all. This goes way beyond aesthetics. We're talking about fundamental things. Structure, health, safety. Is the roof sound? Is the plumbing working? Is it safe?
And you mentioned it's non-negotiable, so even if the lease tries to waive it?
Nope. Doesn't matter what the lease says on this point, this right exists, period. Landlords must provide a habitable dwelling.
Okay, that's a powerful baseline. So what actually crosses the line? When does a problem make a property legally uninhabitable? What's that standard?
The legal term is that the property substantially lacks certain essential features. It's not about minor inconveniences. It's about serious issues affecting your health and safety.
Can you give us some examples? What does substantially lacks actually look like for a renter?
Sure. Think about effective weatherproofing. If your roof leaks badly or walls, windows, doors don't keep out the elements, that's a major issue.
Okay. What else?
Plumbing is a big one. Lack of hot and cold running water. Serious sewage backup problems. Heating systems that don't work properly. Electrical systems that are faulty or dangerous.
What about cleanliness or pests?
Definitely. Unsanitary conditions are covered. This includes issues like significant infestations of insects, vermin, or rodents. Now, the law usually talks about an infestation, not just seeing a random bug now and then.
Right, it needs to be a real problem.
Exactly. Also, lack of adequate trash cans, floors, stairways, railings that are in bad repair and unsafe, and, critically, a lack of working smoke detectors and carbon monoxide detectors. Those are specifically required by law.
You mentioned carbon monoxide detectors earlier. Why are they so important?
Because carbon monoxide is, well, it's the silent killer. Odorless, colorless gas. If you have fuel-burning appliances, like a gas stove or heater, or an attached garage, California law requires the landlord provide working CO detectors. It's basic safety.
And these often connect back to specific codes, right? Health and safety codes.
Yes, absolutely. For instance, California Health and Safety Code Section 17920.3 lists specific conditions that make a building substandard, things like lack of sanitation, dampness that endangers health, even significant visible mold growth.
Okay, so the landlord has these major duties, but what about the tenant side of things? What are our responsibilities?
Good point. You, as the tenant, generally have to keep your own unit clean and sanitary. Sort of common sense upkeep.
And if I break something accidentally?
Then you're generally responsible for repairing damage you cause or that your guests cause beyond just normal wear and tear. And crucially, you need to tell your landlord promptly about any needed repairs.
How should you tell them? Does a phone call work?
A phone call is okay to start, especially for emergencies. But you absolutely should follow up in writing. Text, email, even a formal letter. Keep a copy. Documentation is key.
Okay, so I've notified the landlord in writing. How long do they have? You hear about this 30-day rule.
Yeah, generally the landlords have a reasonable time, which is often presumed to be 30 days, after getting proper notice to make repairs.
But what if it's like December and the heat is totally broken? 30 days is a long time.
Right. For urgent issues, things that immediately threaten health or safety, that reasonable time is much, much shorter. Think days, not weeks.
What if the landlord just doesn't fix it. Even after written notice and waiting a reasonable time, what can a tenant actually do?
Okay, California law gives you a few options, but you need to be careful. One is called repair and deduct.
How does that work?
If the landlord fails to make necessary repairs after notice, you might be able to pay for the repair yourself up to the cost of 1 month's rent and then subtract that amount from your next rent payment.
Ah, okay. Are there catches?
Yes, definitely catches. Big ones. First, you can only use this remedy twice in any 12-month period. Second, the problem can't be something you caused. And third, you absolutely must have given the landlord proper written notice and a reasonable chance to fix it first.
So it's not a blank check?
Not at all.
Yeah.
It's a limited tool for specific situations.
What about just stopping rent payments? Withholding rent?
That's another potential option, rent withholding.
Yeah.
But this one is really risky, very risky.
Why risky?
Because if you withhold rent and the landlord believes you weren't legally justified, maybe the issue wasn't severe enough or you didn't give proper notice, they can start eviction proceedings against you.
Oof, okay.
Yeah. So our strong recommendation, especially coming from a firm that handles eviction defense for tenants, is always get legal advice before withholding rent. Seriously. Sometimes paying rent into an escrow account is suggested, but talk to a lawyer first.
Makes sense. Are there other avenues besides dealing directly with the landlord or withholding rent?
Yes. You absolutely have the right to contact your local code enforcement agency. That could be the city or county building department or the health department.
Then what do?
They can inspect the property. If they find code violations, they can officially order the landlord to make repairs. And in really severe cases, like if the place is dangerously uninhabitable, they might even order you to move out temporarily and require the landlord to pay for your relocation.
Wow, okay. Let's dig into a couple of specific hazards tenants often worry about. Mold. What's the deal with mold in California rentals?
Mold is tricky because California doesn't have a single specific state law outlining exact mold cleanup procedures like some states do, but it's still covered.
Yes. Significant mold growth or persistent dampness that could cause mold and affect your health is generally considered a breach of that implied warranty of habitability we talked about. It makes the place potentially unsafe or unhealthy.
So it falls under the general livable conditions requirement. Exactly. Plus, landlords have a duty to disclose known mold issues before you sign a lease. If they know about it or even reasonably suspect a problem beyond certain limits, they have to tell you. The state health department basically says visible mold or water damage implies a potential health threat.
So the landlord could be liable if they knew or should have known and didn't fix it.
Correct. If they were negligent in causing it or letting it continue.
Okay, what about bed bugs?
Yeah.
Nightmare scenario for many renters.
Ugh, yeah. Bed bugs are awful. California law has some specific rules here. Landlords mustn't...
Why adjacent units?
Because bed bugs spread easily. They also have to bring in a licensed pest control operator, a PCO, to inspect surrounding units if an infestation is reported.
And the tenant, do they have obligations?
Yes, you're expected to cooperate. Follow the PCO's instructions for preparing your apartment for treatment that's really important for it to be effective.
Any other protections?
A big one. Landlords cannot knowingly rent out a unit that has an active bed bug infestation. And they have to give new tenants specific written information about bed bugs, what they look like, how to prevent them, how to report them.
Good to know. We already touched on carbon monoxide detectors being mandatory.
Absolutely mandatory if there's a fuel-burning appliance, fireplace, or attached garage. Non-negotiable safety requirement. Landlords must provide and maintain them.
So California tenants clearly have these rights regarding repairs and safety, but what happens if you actually try to, use these rights? Can the landlord punish you for asking for repairs?
That's where retaliation protection comes in. And this is a huge EE, often hidden, right? California law strongly prohibits landlord retaliation.
Meaning?
Meaning your landlord cannot legally take negative action against you because you exercised a legal right, like requesting necessary repairs or reporting unsafe conditions to code enforcement or even joining a tenant union.
What kind of negative actions count as retaliation?
Oh, several things. Suddenly hitting you with a big rent increase shortly after you complain. Cutting back services like access to laundry facilities. Harassing you, trying to evict you on bogus grounds, even making false accusations.
How do you prove it's retaliation, though? That seems hard.
It can be, but California law gives tenants a powerful tool here. The presumption of retaliation.
Presumption.
Yes. If your landlord takes one of those negative actions like trying to evict you or raising the rent significantly within 180 days, that's about 6 months after you've exercised a protected right.
Like requesting repairs in writing.
Exactly. If that happens within 180 days, the law automatically presumes it was retaliation.
So the landlord has to prove it wasn't retaliation.
Precisely. The burden shifts to them to show they had a legitimate, non-retaliatory reason for their action. It's a very strong protection for tenants who speak up.
That's incredibly important to know. Okay, one last area. Latent defects. What does that mean?
Latent defects are basically hidden problems, flaws in the property that you couldn't reasonably discover during a normal inspection when you moved in, but they cause issues later on.
Like faulty wiring inside a wall.
Could be. Or a hidden plumbing leak, a foundation issue that wasn't obvious, things that weren't visible but were there.
And whose problem is that?
It can still be the landlord's responsibility under the warranty of habitability, even if it was hidden. Proving it can sometimes be complex, maybe involving builders or previous owners, depending on the situation, but the first step is the same. Notify your landlord in writing as soon as you discover it. Document everything.
This has been really enlightening. It's clear tenants in California have significant rights, even if they feel a bit hidden sometimes.
They really do. And knowing these rights is honestly the first most critical step to protecting yourself.
So wrapping up, what's the main takeaway for listeners?
Document, document, document. Keep records of all communication about repairs. Take photos, videos, keep copies of letters, emails, texts, and don't hesitate to seek legal advice if things get serious or you feel the landlord isn't responding appropriately, or especially if you suspect retaliation.
And if you are a tenant dealing with these kinds of issues in Southern California?
Yes, if you're in Orange County, Riverside, San Diego, or Los Angeles and need help with habitability problems, safety concerns, eviction notices, or retaliation, please visit us at martinezlawcenter.com. Remember, we only represent tenants.
Excellent. So a final thought for everyone listening. Now that you know more about these crucial rights, what's one step you can take this week to ensure your home is safe? And what questions do you still have about your specific rental situation? Something to think about. Thanks for joining us on The Deep Dive.
Call now 714-442-9741. Thank you.